17 days. That is exactly how long two roommates had been the legal owners of their cat before a stranger called demanding they hand her over. And when the threats of a lawsuit started flying over a 7-year-old long-haired cat named Star, a quiet corner of Pennsylvania property law was about to be stress-tested in a way that exposes something most pet owners never think about. Here's the full story. To understand what happened here, you have to understand the winter Pennsylvania was having in early 2026. This wasn't a normal cold season. We're talking record-breaking lows, blizzard conditions, and 16 inches of snow blanketing entire neighborhoods. It was, by most accounts, the harshest winter the region had seen in decades. And it was in the middle of all that a 7-year-old long-haired cat named Star ended up at the local SPCA. Star had been living as an indoor-outdoor cat, an arrangement her family had maintained for years. She would go out, explore the neighborhood, and come back home. It was routine, normal, until the temperatures dropped, the storms rolled in, and one day Star simply didn't return. Somewhere in that frozen chaos, she ended up surrendered to the shelter as a stray. And that's where the legal clock started ticking. When a stray animal arrives at a shelter with a microchip, standard protocol kicks in immediately. The shelter checks the chip, identifies the registered owner, and reaches out. That's exactly what the SPCA did. They found Star's family, they made contact, and then they waited, and received no response. After the legally required holding period expired with complete silence from the family, Star was cleared for adoption. On March 1st, 2026, two roommates walked into that SPCA and legally took her home. Now, before we go any further, I want to be fair here because this case has real emotional weight on both sides. So let's start with the original family. They had this cat for years, 7 years. She was part of their home, part of their routine. When she disappeared in the middle of a brutal winter, maybe they assumed she'd come back. Maybe they held out hope. Maybe the chaos of daily life, especially during blizzard conditions, made it genuinely difficult to coordinate with a shelter. I want you to sit with that for a moment. Their position was straightforward. Star was their cat. She had their information on file via microchip. They hadn't surrendered her, she had gotten lost. And when they finally found out she was in a shelter and had already been adopted out to strangers, the emotional response, the anger, the grief, the urgency, is something any animal lover can understand. They wanted her back. That's a human reaction. The question is whether it was a legally viable one. Now consider the other side, two roommates who did everything right. They went through a legitimate adoption process. They paid the fee. They signed the paperwork. They brought Star home and immediately started caring for her, cutting matted fur from her back legs, keeping her warm through a historic winter. 17 days into their new life together, they got a call from the SPCA saying a family had shown up and wanted the cat back. Their first instinct wasn't to fight. They took a day to think. They called the shelter and asked thoughtful questions. What they learned when they asked those questions is what changed everything. The SPCA told them the family had been contacted over a month prior, that no response was ever received, and that the family's own explanation, provided directly to the shelter, was that they had, quote, just noticed she was missing the other day. In one of the coldest winters Pennsylvania had seen in decades, for a cat who had been at the shelter long enough to be held, cleared, listed for adoption, and adopted out, that explanation raised serious questions. Based on all of that, the roommates made their decision. Star was staying. And when they communicated that to the SPCA, the situation escalated fast. The original family threatened legal action. The branch manager called. And suddenly 2 people who had simply adopted a cat were staring down the possibility of a civil lawsuit from a family that owned land, had a large home, and by implication, had the financial resources to make this very expensive, very fast. So here's what I want to ask you. What would you do? Drop your answer in the comments below, because this exact dilemma plays out in court more often than most people realize. Let's talk about the law, because this is where the emotional reality of pet ownership crashes head-on into legal reality. In Pennsylvania, and in the vast majority of U.S. states, pets are classified as personal property. Not family members, not dependents. Property. That might sound harsh, but it carries significant legal weight. It means disputes over animals are governed by the same framework as disputes over cars, furniture, or any other personal item you own. Whoever holds valid legal title wins. When a stray animal is brought to a shelter, the law establishes something called a holding period, a window of time during which the original owner can come forward and reclaim their pet. The length of that window varies by jurisdiction, but the key principle is universal. The clock starts, and the burden is on the owner to act. In Pennsylvania, shelters operating under state humane law are required to hold animals and make reasonable efforts to notify identified owners. Once that period expires without a response, legal ownership transfers to the shelter. Full stop. In this case, the SPCA followed that process by the book. They identified Star's family through her microchip. They made contact. They waited through the entire holding period. When no response came, Star became shelter property. And when the shelter completed a lawful adoption on March 1, 2026, legal title transferred to the new owners. Under Pennsylvania property law, that transfer was binding. The question now was whether the original family had any legal theory strong enough to undo it. So what arguments would the original family's attorney actually bring? Let's walk through them, because this is where the case gets genuinely interesting from a legal standpoint. The first theory, inadequate notice. The argument would be that the SPCA outreach efforts were insufficient, that the family never truly received a proper legal notification, giving them a real opportunity to respond. It sounds plausible until you stack it against the facts. The shelter had time-stamped records. The family's own admission that they just noticed the cat was missing obliterated the inadequate notice argument before it could even get started. The second theory was more creative, and it's one that's actually been raised in courtrooms across the country in recent years. The argument goes like this: a microchipped animal can never truly be considered abandoned because the microchip itself represents a permanent, continuous assertion of ownership. It's clever. It has some surface-level appeal. But courts have consistently rejected it when the registered owner failed to respond to direct shelter outreach. A microchip is an identification tool. It is not a legal override of the holding period process. The third angle involved something courts have only recently begun to grapple with: the intrinsic emotional value of a companion animal. Some jurisdictions have started allowing claims for loss of companionship when a pet is wrongfully taken or harmed, recognizing that the grief of losing an animal goes beyond the animal's market value. But here's the critical problem with that argument in this case. Star wasn't dead, and she hadn't been harmed. She was alive, healthy, and in a loving home. The family wanted possession, and courts treat possession disputes as property disputes. Meanwhile, the adopter's position was rock solid. A completed, documented adoption. Written communication from shelter staff confirming they held full legal claim. 17 days of documented care, including veterinary attention to the matting on Star's legs. And perhaps most powerfully, a direct statement from a shelter employee that it was her professional opinion Star should remain with the new owners. That kind of contemporaneous documentation is exactly what an attorney needs to defend a case like this. This is a pattern that comes up constantly in civil disputes, and it's one you need to understand. A financially superior party makes aggressive legal threats, hoping the other side doesn't have the stomach or the savings to fight back. The original family-owned land had a large home, presumably had access to legal counsel. And the roommates, they were two people who had adopted a cat. The threat of costly litigation is often the weapon, not the lawsuit itself. The question in moments like this is simple: do you fold or do you hold? They held, and when the legal analysis played out, the conclusion was unambiguous. Under Pennsylvania law, the adoption was valid. The SPCA had followed every required step. The family's failure to respond to the shelter's outreach for over a month, in a case where their contact information was on file, had legally extinguished their claim. No Pennsylvania court was going to order the return of a lawfully adopted animal to a family that had, by the statute's own standards, failed to exercise their right to reclaim her. The case never reached a courtroom, because once a competent attorney examined the facts and the applicable statutes, the path forward simply didn't exist. The adoption was clean. The documentation was comprehensive, and the single most damaging piece of evidence in the entire dispute was a statement the family had made themselves to the shelter on the record that they had only just noticed their cat was missing. In legal terms, that statement is devastating. It speaks directly to the question of due diligence, and the answer it gives is not favorable. Courts evaluate property disputes through the lens of conduct and diligence. What did each party do? When did they do it? And did they act in a manner consistent with someone who genuinely cared about the outcome? A family that allows weeks to pass without noticing a pet is missing, fails to respond to shelter contact, and then, only after an adoption is completed, comes forward demanding the animal back, does not present a legally compelling picture. Sympathy, perhaps legal standing, that's a much harder case to make. Star stayed home. The two roommates who had taken her in cut the mats from her fur, sheltered her through 16 inches of snow, and refused to back down in the face of legal pressure. They kept her. The SPCA closed the file. And somewhere in Pennsylvania, a long-haired 7-year-old cat settled into her new life, completely unaware that she had been at the center of one of the more interesting property disputes animal law attorneys would discuss that year. The implications of cases like this one extend far beyond any single cat in any single Pennsylvania town. Animal shelters across the country are navigating an increasing number of post-adoption disputes, situations where original owners appear after the legal window has closed and challenge completed adoptions. And the outcomes consistently reinforce the same principle. The holding period process exists for a reason, and failure to participate in it has legal consequences. For shelters, the lesson is operational. Documentation is everything. Time-stamped contact logs, written records of every outreach attempt, clear internal protocols that define exactly when an animal transitions from hold to available for adoption. The SPCA in this case had done that work, and because they had, the adopters walked away with clear legal footing and an unassailable paper trail. In the absence of that documentation, this case could have been far murkier and far more expensive for everyone involved. If you have adopted a pet and are wondering about your legal rights, or if you're currently facing a situation similar to this one, the description below has a breakdown of animal property law by state, including what the holding period requirements are where you live and what to do if someone threatens legal action over an adopted animal. Know your rights before you need them. And if you want to see another case where property law and genuine human emotion collide in court in a way that surprised even